What would a brand owner call a robe that keeps you dry? Dryrobe? Well, a case that was decided late last year brings this into question whether or not a descriptive name can be a trademark. In that case, this particular case, the product in question is Dryrobe, which has become a very sought after brand item. The product first came into the market as a kind of sportswear, very loose-fitting robes for swimmers or climbers to change under. But because the branding was quite unusual, the name itself is very distinctive and memorable. Therefore, it's now a very popular fashion item. Now, you will hear me saying that the brand itself is distinctive, but that is exactly the problem with it, actually, because is it actually distinctive or is it actually descriptive of its product? Many brand owners, they struggle to find names that are memorable, distinctive, stands out in the consumer's mind, and yet they would also quite easily try to think about names that are descriptive of its product. For instance, if you are using terms that describe your product, it might be more easy to be searched and found on the internet. And maybe it's easier to find a URL that is easy to remember for the consumers. In the case that was decided late last year, a competitor called Dryrobe was challenging the validity of Dryrobe's trademark, arguing that it has become generic and that it lacks distinctiveness. So the problem of genericism is a big issue in the trademark world. This is an issue that IP lawyers have always been fascinated by, and many very famous brands have either survived it or fallen foul of it, basically. The problem here is that when a product is so successful that consumers start referring to its name as the product itself, for instance, in the case of Hoover, we would just look for a Hoover and not a vacuum cleaner. It loses its role as a trademark. And the same applies here. Do we call a big robe to keep you dry a dry robe, or are we actually referring to the brand itself? So fortunately for the company, in the case that was decided late last year, the court did agree with it that the name was not generic and that it was sufficiently distinctive to act as a trademark. However, it is undeniable that the name has elements of descriptiveness, and it may be an issue that will be revisited again, as with many other brands in the market where they are using names that describe or partially describe the product.